Hello and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. All right. Hey, everyone. I am so excited to see you guys here. I see that there are some people in the chat, some people watching. I am really excited for this live stream because I recently, I don't know, I knew about this case for the last however many years it's been going on, but it was sort of in the periphery. And a lot of that I think has to do with the media not really reporting this so much. But for some reason, I think um, somebody tweeted tagging me and maybe Nick or Kata or something talking about this, about the possibility of this trial being live streamed next month. And so I kind of started to dig much more in depth into this case and I feel like I'm like Alice in Wonderland down a rabbit hole and just spending pretty much all of my time and really getting to know this case very well. And I'm like on the level right now that well, number one, I want to live stream this trial. If they do allow cameras in the courtroom, I really want to live stream this trial on my channel, from soup to nuts, beginning to end. And at the same time, and if they don't allow cameras in the courtroom, I'm already, if you're watching, if you're new to this channel, I live overseas right now, but I'm planning to be on the West Coast in early April. And so I'm thinking I'm just going to book some tickets and fly to DC, the DC area. I have a lot of family and friends in that area anyway. So I will definitely be going and getting my butt into the courtroom to try to watch the trial myself and give all of the first person account updates on the trial if there is no media coverage of this trial, because it's just so interesting. It's so crazy. All of the facts that have come out in this case. There are a lot of twists and turns. The more that you learn about it, the crazier it gets. So anyhow, and yeah, I see in the chat, live streaming with that umbrella guy. I have been in communication with him. He's been super helpful. First of all, he's been super helpful with getting me information to help me get up to speed on this case, and sort of sending me in a bunch of different directions. I've seen, like, on Twitter, the real Laura B, she and Jax have a podcast. They have a series that is the Road to Fairfax. I've been listening to that podcast. I've been watching that umbrella guy's videos. I've been watching some other channels videos. And so I'm going to keep going down that whole rabbit hole. And I would love to be collaborating with all of these people, because I know that they've been in this space for like years now. And I think that it's a crazy case. And I think that it'll be very helpful actually for me to be able to talk to people that have a very, very detail oriented understanding of this case. So anyhow, with that said, so as I said, I'm still very much getting up to speed on it, but as I go along, I want to be updating with some content here and there. So I figured I would start with the motion for summary judgment that was filed by Johnny Depp's legal team at the end of February. So it's a little late. It's not exactly like the most current thing, but since not that many people are talking about it, other than these various people that have been in the space for a long time, I figured I would go through, break it down, let you guys know what my thoughts are on this, on this particular motion, and what what we might be looking at coming at what might result. Anyhow, so we are going to get into it. And also, if you guys like, send me DMs for, places to go. I saw Lost Beyond Pluto, so I saw that. Yeah, I've checked out that channel for some content. I haven't been able to see too many of her videos, but I did see that she's somebody that I'd love to reach out and get connected and whatnot as well, on this particular subject. So what else? Okay, so let's get into it. Let me share my. Of course, I could have prepped this ahead of time and shared my my freaking, what's it called? Where is it? Where am I? What am I doing? Oh, did I close out of it? I am so sorry, guys. This is so unprofessional. Let me pull up the PDF, because apparently in my efforts to get everything ready for this live stream, apparently I closed out of the actual motion that I'm going to be talking about. That's really brilliant. Okay. All right, here we go. Okay. And so now I finally pulled it up. I'm sorry, guys. That was really dumb. Okay. Here we go. Share. All right. So, all right, bring this up a little bit more. And okay, so here's what I have found for the motion for summary judgment. So I'll start off by saying that typically a motion for summary judgment is, at least, so my experience with a motion for summary judgment. Oh, hey, that umbrella guy. Hey, how's it going? Glad to see you in the chat. So yeah, we need to get back in DMs to talk about when we can collab on a live stream or something like that, because I definitely want to. Okay, so what I was going to say about a motion for summary judgment. So my experience has always been in California with motions for summary judgment. And typically what you will see with the actual filing itself, at least in California, I don't know if it's different in Virginia, but I would have expected it to be something similar, where you have a memorandum of law and support that basically it lays out your entire argument for the motion, right? It gives the facts, it gives the law, the legal support for why the opponent's claims or counterclaims should be dismissed. Then you have what's called a separate statement, which is basically this is where like the really big busy work is. And I can understand why that may not have been attached to this version that you can find on the internet, because it really weighs down the document, because it ends up taking way more paper than the actual argument itself. Because what it is it basically takes all of the elements that the other side has to prove, and then it says, like, the allegations, and then it has like a box where you need to put in, your evidence for why your side should win and why the other side doesn't have any evidence for their claim. Anyhow, so I kind of expected to see that with this for some reason, but this is just the memorandum of law in support of the plaintiff's motion. So, I mean, this is ultimately, when we're talking about the actual arguments of the motion, this is really like the most important part that we want to be looking at to analyze. But it would have been helpful to look at something like a separate statement that would have kind of shown how their evidence kind of measures up, and how the plaintiff's evidence doesn't measure up. But it just would have been, I guess, ideal, but it's not really necessary for our purposes. But anyhow, okay, let's get back into it. Okay, so this is actually a very simple motion for summary judgment. There are three main arguments here, and it's actually relatively simple. And in order to really explain things further, you kind of have to give a little bit of context for the timeline of events that happened. So we have the and I'm talking about the litigation timeline. I'm not talking about, going all the way back to 2015 with the various fights that they had, and, who, like, whether or not there was, wine spilled on a wall, or there was a dent in a door, things like that, because there's a lot of detail in this case. I'm just talking about the complaint was filed in when was it? It was in 2019. I'm sorry. I'm trying to look at my notes here because there's just a lot of detail, and my memory is terrible, by the way. So I can never rely on my memory for any kind of details like this. I have always been that way. Um, so anyhow, um, excuse me for a second, guys. I'm so sorry. This is okay. I want to make sure that I have this correct. Okay. So 2019, March 1st is when Johnny Depp filed his complaint for defamation against Amber Heard. Then on August 10th, 2020, so like a year and a half later, Amber Heard filed a counterclaim. And the basis of, without getting into too much detail for the complaint and the counter complaint or the counterclaims, the the basis of the defamation claim, and I'm sure if you guys are here because you are part of the like Johnny Depp, like Justice for Johnny Depp community, I'm sure you know this already, but for anybody that is kind of new to this case, I want to make sure that people kind of understand where things are coming from. So the basis of Johnny Depp's lawsuit is that Amber Heard published an op-ed in the Washington Post in the end of 2018, in the midst of the Me Too movement, basically talking about how she was a victim of domestic abuse. And she didn't exactly come out and say that it was Johnny Depp, but everybody kind of knew that it was Johnny Depp based on the reading of the article and kind of the timing of things, because she had been through a messy divorce with him back in 2016 and that kind of thing. So anyhow, so she laid out all kinds of allegations there, and pretty much immediately afterwards, he was set to continue headlining in his role as Captain Jack Sparrow in the next Pirates of the Caribbean movie, basically for the foreseeable future, because it was good business for Disney, I guess. And he really enjoyed doing it. I remember hearing around that time that, like, Disney basically was like, so long as you want to continue doing this job, like, we'll give you the role. That was what I had heard from people that, worked around Disneyland, that kind of thing. So I don't know if that's actually true or not, but that was just, I remember what I remember hearing at the time. He also had one of the headlining roles in Fantastic Beasts and Where to Find Them. So obviously these are two really big franchises, right? Pirates of the Caribbean and the Harry Potter franchise, that he had very large roles in. They were very lucrative, very good for overall business. And so shortly after the Washington Post published this op-ed by Amber Heard, he lost both of those roles. And he basically, I haven't seen him in any movies since then. It sounds like he's been basically what's the term for it, blackballed in Hollywood, right? Especially in the midst of the Me Too movement, where this was like such a huge deal. And you've got Weinstein and all these other people in Hollywood that suddenly were taken down from their very for some very powerful roles, blacklisted. Thank you. That's in the chat. Anyhow, so he was one of these guys that basically got canceled as a result of the Me Too movement. And so his defamation, or his lawsuit, basically says the claims that she made in this Washington Post article are defamatory. They are complete lies. They are fabrications. And he's lost a lot as a result. So the basic elements of defamation are that somebody made a statement that was false about the plaintiff, and that the publishing of that statement to third parties caused them damages. Now, in this particular case, because we are talking about somebody where the allegations are so bad that they are that they have a certain sense of moral turpitude, something like domestic violence is going to be one of those kinds of allegations. We are talking about not just defamation, but defamation per se. So just a really quick rundown on defamation and defamation per se. Basically what that means is that he doesn't actually even have to prove his damages, because it's like the nature of the allegations is just so bad that anyone would know that that would cause massive harm to his reputation. We saw the same thing with the Cardi B defamation lawsuit that happened recently, where she actually won big time, not just in compensatory damages, but also punitive damages. And it was a really big deal, because I mean that one was kind of crazy, because literally the defendant admitted on the stand, I knew that what I was saying was probably not true, but I said it anyway, and I was happy to do it. That's my business. That's what my business is based on. So anyhow, so that's the basis of the complaint. The counterclaims filed by Amber Heard are basically saying that he was making all kinds of defamatory statements against about her. Basically, his statements saying that he didn't abuse her. I don't. Looking at the counter complaint, I'll admit I haven't been able to spend as much time with the counter complaint at this point yet. I do know I did read through the court's opinion letter on Johnny Depp's latest demur on the counter complaint, or on the counterclaims, where he basically cut down most of her allegations. And that's why I haven't really dug in too deeply into her counterclaims just yet. But basically what the court said was she had like all kinds of statements that she was alleging were defamatory. I mean, it was like statements A through H, right? And so A through E, the court said, these are all time barred. They fall outside of the statute of limitations. It should have been within 1 year, told by the beginning of this lawsuit. That's kind of I won't get into tolling too much, but basically that she gets a little bit more time than 1 year, because of the fact that Johnny Depp had filed this particular lawsuit. So she has actually a little bit more than 1 year for the statements to be sort of included. Anyhow. So basically what the court narrowed her counterclaims to is 3 statements, all of which were made not by Johnny Depp, but by his lawyer, and in relation to the lawsuit that he filed previously against the Sun in the United Kingdom. And that's important because maybe towards the end, I might talk a little bit about something called litigation privilege. It's something that doesn't come up in the motion for summary judgment. So that's why I'm probably going to leave that until the end. But it's interesting to me that it's not in this motion. And I haven't seen the actual demur. I haven't been able to find the demur that Johnny Depp actually filed for the counterclaims previously. I only saw the court's opinion on that initial filing. So I don't know exactly what the arguments were by Johnny Depp's legal team for the demur to the counterclaims before. But I basically know more or less what the summary of those arguments were, based on from reading the court's opinion. Okay. So anyhow, all of that is to say, that was kind of a very long explanation, but basically to say that there are 3 main statements here that are at issue. So in this motion for summary judgment, basically the bird's eye view of this motion is that those 3 statements should all go away, because they are because all of them, for one reason or another, should not go in front of a jury. Basically, because either either she can't prove that it was attributed to, or she can't prove that Johnny Depp was even involved in those statements because he isn't the one that said them, or she can't prove that the person who actually said them said them with the proper level of intent, or that that these were even statements that are subject to defamation. Now, as I said before, there was a demur, and the court did analyze it. And so the three statements that were left, the court had looked at these and looked at the arguments by Johnny Depp and by his legal team, and decided that those were statements that could proceed in the litigation. Now, those statements are being revisited in the motion for summary judgment. And so let's look first at, or I guess talk first about the difference between a motion to dismiss or a demur. Those two are the same thing. They're just two different names depending on the jurisdiction. Motion to dismiss, federal court always calls it a motion to dismiss. Some states like Virginia, California, they call it a demur, but it's the same exact thing. It's just a different name. So there's that, and then there's a motion for summary judgment. These are two different parts in the litigation, and there's different standards for the two of them. Now, a motion to dismiss or a demur basically looks at the allegations that are alleged. Allegations that were alleged by the claims that are alleged by the plaintiff. And the court will assume that all of the facts that are alleged are true. They won't take any kind of legal conclusions as true, but they will say, okay, if somebody alleges on this date, this happened, on that date, that happened, on that date when defendant did this thing, they did it intending to do so. The court isn't going to look at, weighing any of those allegations about whether or not they might be true, might not be true. But instead, the court is going to assume that those are true and just say, are there any gaps in your allegations? Like, for a defamation claim, do you actually allege that there was some kind of a lie? Or is there no allegation that the thing that the person said was a lie? Because that's a material element to the case. If you can't even allege it at such an early stage, how can you possibly prove it later on with actual evidence? So it's an early way to get rid of litigation that just shouldn't be in the courts in the beginning. But it's a very, very, very low standard to meet. So just because a certain number of claims have survived a motion to dismiss does not mean that they are automatically going to also survive a motion for summary judgment. It doesn't mean that it's going to succeed at trial, even, because you don't have any actual evidence in front of you when you're looking at a motion to dismiss. Or, what you're looking at is just the allegations in the complaint. Anyone can allege anything. It's up to the discovery stage to actually get the evidence and to be able to provide it so that you can actually prove those allegations. Now, a motion for summary judgment happens either during or at the end of the discovery phase. You can actually do this pretty much at any point during the discovery phase. The discovery phase is when the two sides are exchanging information with one another. And you do this there's different kinds. You can request documents from the other side. So if there's anything involving finances, usually you'll ask for bank records or tax returns sometimes, or if it's a personal injury case, you're getting medical documents, for example. Then you've got interrogatories where you are asking open-ended questions saying, state all facts, proving that this statement that this person said was a lie. Something like that. So then there's other like yes, no questions. So anyhow, so in that whole process, the two sides are supposed to be exchanging information with one another. And this can get very tricky because the one side might not necessarily want to give all of the information, if there either isn't information to give, or if the information that they have to give is not necessarily very good. And you have a certain amount of, it's all by the time at which you have to respond to these things is it's all very, very methodical. Like somebody sends a bunch of discovery requests, and usually you have like somewhere around a month to respond. You can ask for an extension or whatever, but basically you have a certain amount of time to produce. If you don't ask for an extension, then you start to get into some issues with one another. But anyway, that's a bit of a digression. But when you do have discovery responses from the other side, then you can start to file what's called a motion for summary judgment, where basically you say, and usually, so either side can file this motion, but usually it's going to be filed by the defendant. And in this case, it's filed by the plaintiff, but it's filed by the plaintiff as to the defendant's counterclaims. So yeah, I'll leave it at that without giving more detail. That's just not going to help. So usually it's done by a defendant. And so even though Johnny Depp is the plaintiff in this case, for purposes of the motion for summary judgment, you can kind of think of him as the counter defendant because it's counterclaims. So, what they do is they say, okay, the other side has to prove elements 1, 2, 3, 4, 5. And if any single one of those has a box that's left unchecked, they don't have evidence for any single one of those boxes, the court can enter a judgment in my favor. And that's because the other side has a burden of proof. So in this case, as regards the counterclaims, we have Amber Heard has claimed that there are 3 statements by Adam Waldman, Johnny Depp's attorney, that were defamatory about the, and this is about the, what was I going to say? Oh, sorry. I got distracted from some notifications that I just got. Okay. So if there are certain boxes that are left unchecked, the other side has a burden to prove every single element. So if they don't have evidence for one of those elements, that entire claim goes away. So in this particular case, we're just looking at defamation per se that's alleged by Amber Heard. And so she is the one in that case that has the burden to prove that Johnny Depp, or not Johnny Depp, Johnny Depp's lawyer, he made certain statements that not only were lies and not only were about her, not only were published to at least one third party. All of those 3 things can be true, but most importantly, because we are talking about a public, because we are talking about a public person, a public, oh God, what's the term for it? I've been like living this for so long. Public figure. Okay. Because we're talking about a public figure, we have to, she has to prove that this person made this statement with actual malice. Actual malice means that, somebody made the statement either knowing that it was false or with reckless disregard as to whether or not it was false. So, for example, I mentioned the Cardi B lawsuit earlier. I really like talking about that one because it's a really good example of actual malice, because Cardi B had the same sort of standard, which is really difficult to prove, right? Because it's not just like a normal person. It's not just like a normal person that can show that somebody made the statement negligently, basically meaning that they should have done some better due diligence before running their mouth off and lying about this person, right? We are talking about somebody that has a much higher burden to prove that whoever it is made this statement either knew that it was false or basically ignored the possibility, the likelihood that it was false. So, the example from Cardi B is that the defendant in that case on the stand said, I knew that what I was saying was probably untrue, and I said it anyway." So that is not knowledge, but that is recklessness. That is recklessness as it relates to actual malice. So in this case, Amber Heard has to prove that Adam Waldman made these statements with actual malice. And that is a very, very difficult standard. So, and the reason for that, by the way, and by the way, Johnny Depp still has that. He has the same burden on his side, and we'll get into that in a different video because we can talk more about his actual things, but we're just going to kind of limit this one to the motion for summary judgment because it's already going to take quite a bit. I haven't even gotten into the substance of the actual motion. But the whole purpose of why this is why it's actually kind of a good thing that we have this is because public figures are out. They have essentially megaphones wherever they can go, right? They tend to garner a lot of attention. So things that they say, they are able to correct misstatements by other people. They are able to sit down with people like George Stephanopoulos and have an interview and talk about their side of things that are out in the news, right? Um, and so the idea is it really comes from the First Amendment that the ability that or the idea that we need to be able to comment on not just things of importance but public figures as well, because public figures usually are involved in events and incidents of national importance, community importance, what have you. So if we were to allow the negligence standard for public figures, people would have to be extremely careful about how they talk about literally everyone that is relatively famous, right? And that is just such a difficult thing to do when we have people that are extremely well known. So, is it fair to someone who's a public figure, especially to people who become public figures, not necessarily because they have chosen to become public figures, but because they've been thrust into the limelight? Like say, for example, Kyle Rittenhouse. Like I don't think that he intended the night that he went out to Kenosha with a rifle, like he didn't necessarily intend to become some nationwide, public figure. I don't think he intended that, but he kind of was thrust into that because of the circumstances of that night. And then he became a public figure. But anyhow, so is that fair? I don't know. But the idea is that overall, for the good of the community, I guess, of First Amendment rights, that ultimately is what the courts decided was most important when it comes to public figures. So that's why we have that. Okay. Let me get a few super chats because I just realized that there were a few that I did not address. Britt Cormier, thank you so much for your super chat. Where do you think Amber falls on a scale of 0 to bag of cats crazy? So I will say I am every time that I come into a new case, I'm trying to be as objective as possible, and maintain my objectivity as much as possible, because I really want to. Um, I never want to put myself into a complete echo chamber, and I never want to, uh, lose that analytical side of my brain. But I will say, I have seen little bits and pieces of her deposition video footage. A little skeptical about her mental state, um, and about the veracity of her story, we'll say. But I want before I like give a big conclusion on that, I want to say like I want to go through all of that information uh in a I want to go through all of that information in much more in depth, because if I'm gonna say something that's definitive, I want to make sure it's really based off of as much information as possible. So, um, but maybe more towards the scale of bag of cats of crazy. So we'll see. Cherokee Girl for the law pause. Thank you so much. Crusader Saracen, here's some money for a louse for beer. Thank you so much. I appreciate it. Cheers. And Dragon's Treasure. Thank you so much. Gee, I'm thirsty. Do you know where I can find myself some good loose leaf and now pre-bagged teas with a coupon code? Yeah, you guys. You can go to thedragonstreasure.com. And last month I had a really fun competition with Eric Hunley to sell tea, to see who could sell more tea. That was really fun. So that has ended, but I still have my own why did I pull this down? I still have my own coupon code. So if you do go to thedragonstreasure.com, at checkout, you can put in the code Legalbytes, all one word, and you get 10% off. And it helps me. It helps to, like, I get a little bit of a kickback. The Dragon's Treasure, obviously, you can support their business, which is a small tea business, and the tea is really, really good. So anyhow, oh, somebody wants to know who won. I did. I am very thankful. So thanks, guys. Thank you so much for helping me to win that one. So, but I think it was really close between me and Eric. So that was it's very fun. So anyhow, okay. Let's actually get into this motion now that I've babbled on long enough, I think, with some introductory stuff. So, all right, so these are the basic arguments here. They said, first off, they say that as to these statements that are allegedly defamatory, number one, Ms. Heard has no evidence of direct liability, meaning that there's no evidence that Johnny Depp was directly involved in the statements that were made. Number two, Ms. Heard cannot prove actual malice by Mr. Waldman. So, talking about that actual malice standard, that's a very high burden. Basically saying, even if there was any sort of direct connection between Johnny Depp and Adam Waldman, Johnny can't be liable, because in order for him to be liable vicariously, she would have to first show that Adam Waldman would be liable for defamation, and she can't because of the actual malice standard. Number three, in context, the counterclaim statements are protected opinion. Okay, so we're gonna skip through this. Okay, and we are gonna go through this. It's actually not that long, so I'm gonna read through the whole thing. And hopefully you guys are good with that. All right. Let's see if I can pull this a little bit bigger. Oh, there we go. Very good. Okay. So here we go. Ms. Heard's counterclaim is defective and Mr. Depp is entitled to summary judgment. At issue are three statements, in parentheses, the counterclaim statements, made by non-party Adam Waldman, not by Mr. Depp. Ms. Heard fails to state a valid claim against Mr. Depp for at least three reasons. First, no evidence supports Ms. Heard's allegations that Mr. Depp conspired with or directed Mr. Waldman to make the counterclaim statements. So, Ms. Heard cannot establish that Mr. Depp is directly liable. Second, to the extent Ms. Heard seeks to hold Mr. Depp vicariously liable for Mr. Waldman's conduct, she must establish that Mr. Waldman committed the tort of defamation. But Ms. Heard, a public figure, cannot establish that Mr. Waldman acted with actual malice. Third, in context, the counterclaim statements are non-actionable opinions. Okay. The summary of material facts. Mr. Depp and Ms. Heard had a relationship that ended in a widely publicized divorce amid allegations of domestic abuse, which have been the subject of high-profile, widely publicized litigations in the UK against a tabloid, and in Virginia between Mr. Depp and Ms. Heard. Ms. Heard is a self-described public figure, actress, and activist, and is affiliated with a major film franchise. Ms. Heard seeks to hold Mr. Depp liable for statements that were indisputably made by Mr. Waldman on the theory that Mr. Depp has authorized and conspired with his attorney, Adam Waldman, acting on Depp's behalf, to attempt to destroy and defame Ms. Heard in the press. The counterclaim statements appeared in the UK tabloid The Daily Mail in the lead up to a highly publicized trial in the UK that revolved in part around Ms. Heard's abuse allegations. Statement F is an article with the headline Amber Heard's sexual violence evidence against Johnny Depp will be kept secret in his libel claim against the Sun, despite him arguing claims should be made public. Good Lord, that is a long title, by the way. I don't understand why that title is so long. Anyhow, that's just my comment. And the article contains discussion of the parties' conflicting contentions. The article describes Miss Heard's quote lurid 300-page filing of her own, cataloging the quote horrific abuse she claims to have suffered at Mr. Depp's hands, unquote, and sets out a description of Miss Heard's allegations by a UK barrister adverse to Mr. Depp, who asserts that, quote, Mr. Depp would usually, when under the influence of drugs and alcohol, but not always, flip and suddenly turn into, quote, the monster, and would on those occasions, she says, it was on those occasions, she says, that he lost control and attacked her, unquote. Mr. Waldman's statement appears shortly thereafter, dismissing Miss Heard's, quote, fake sexual violence allegations, unquote, and predicting that Miss Heard's hoax would be obliterated at trial. Statement G. So that's the first statement. So note that this one so far what we're talking about is a statement made by the lawyer about litigation, right? Because this is in reference to the lawsuit against the Sun in the UK, and the article is about the actual litigation, and it has quotes from the Sun's attorney, and it has quotes from Johnny Depp's attorney. So it's quoting both sides here. And the statements made by Mr. Waldman is it's referring to her domestic violence allegations as fake and a hoax, and saying that they would be obliterated at trial. This to me sounds like just about any kind of statement that a lawyer would make to the press about their high profile case. Every time that an attorney that has filed a case like that is going to bring a case like this that has both elements in a court of law and the court of public opinion, you're going to have these kinds of statements that are going to be, made, right? And the lawyer is going to, make these statements arguing for his or her client, because you have this is in the UK, so I don't know exactly what the professional responsibility requirements are in the UK, but I would imagine that they're pretty similar to the United States, where, here you have a duty to zealously advocate for your client. And there are certain rules around, statements to the media, but this to me seems pretty normal so far. There's nothing in this that seems to me that is crazy about this statement by Mr. Waldman. Okay, so that's statement F. Statement G. Statement G starts with a headline. Oh wait, you know what? Let me get some super chats here. Tinley, hashtag super chat. Thank you so much. Your bro and Legal Mindset talked about something disease last month. Amber's one. Also, your fave cartoon anime character. Mine's Batman of the animated series. So I don't know exactly which disease you are referring to, but I'm guessing that it's just something that's not the nicest, and that's okay. So my favorite cartoon slash anime character, I will say, growing up, one of my favorite cartoons was X-Men, and my favorite character on the show was Rogue. I think for a while it was Storm, but mostly Rogue. So, yeah, she was. Yeah, I think overall for the long haul of my childhood, she was my favorite. Anyway, so thank you for the super chat. In Fantasy I Die said, I believe Amber is guilty. Hashtag believe all women. I am I'm still not ready to be fully decided just yet because I haven't gone through everything in detail, but I will say I am kind of leaning that way myself based on what I've seen so far. But I reserve the right to change my opinion because I'm still going through it. So, okay, back to statement G. Statement G starts with a headline, quote, exclusive, I need to report an assault. Listen to the 911 call made the night Johnny Depp and Amber Heard had blowout fight that ended their toxic 18-month marriage, but both claim tape backs up their version of events, unquote. The article describes allegations by Miss Heard and reports that Miss Heard's attorney says that phone records and police department logs vindicate Heard's account of the final shocking episode of domestic violence Miss Heard endured before filing for divorce. The article states, quote, Depp's lawyer, Adam Waldman, said the various discrepancies in Miss Heard's account proved that nothing Heard and her friends said about the events of May 21st, 2016 could be considered credible, unquote. That, quote, this was an ambush, a hoax, unquote, and that, quote, two domestic abuse trained LAPD officers would later provide a pair of sworn depositions saying they saw no evidence of a crime, unquote. The article quotes Miss Heard's then counsel, Roberta Kaplan, calling Mr. Waldman's arguments, quote, fantasies, unquote, asserting that Mr. Depp's representations about the 911 call on the night of May 21st, 2016 are false, and that the evidence, including sworn testimony from multiple witnesses, phone records, and police department logs, supports Miss Heard. So, okay, so the statement in statement G by Mr. Waldman here is he's saying that the various discrepancies proved that nothing she or her friends said could be considered credible. That doesn't seem like anything crazy to me. And the same thing about, that this is an ambush, a hoax. I mean, it does kind of seem a bit more like opinion. And that two domestic abuse trained LAPD officers will. So I think so he's saying that this is what they're going to do. That's not a statement of fact. That is more of a prediction of the future, I guess. Yeah, that's nothing. There's nothing crazy in this statement. I don't see any sort of factual assertion in this one either. Statement H is an article about a friend. And again, by the way, this is also relating directly to litigation. Litigation that was ongoing at the time. Statement H is an article about a friend of Miss Heard's, Amanda de Cadenet, who withdrew her support for Miss Heard after she listened to audio recordings of Mr. Depp and Miss Heard and concluded that Miss Heard had not been forthcoming with her. The article states Miss de Cadenet feels she was used and misled by Amber and is horrified after listening to Miss Heard be, quote, verbally abusive to Johnny, unquote. The article quotes Miss Heard's former attorney as saying, quote, we believe Amber and we believe in Amber, unquote. And Mr. Waldman as saying, when Amanda de Cadenet recants her support for Miss Heard and testifies against her, we have reached the beginning of the end of Miss Heard's abuse hoax against Johnny Depp, unquote. I mean, so I guess what they're latching on to is his characterization of it as a hoax. Okay, I suppose. Mr. Depp's fifth interrogatories to Miss Heard included the following. Quote, state all facts that support your contention that Mr. Depp is responsible for any damages you contend you have suffered as a result of the counterclaim statements, unquote. To date, Miss Heard's only response is to state that Ms. Heard will provide a substantive response. And then it cites to Exhibit 1 at paragraph 3. Now, this obviously cites to exhibits. There aren't any in this version that I have. So I don't know exactly when this interrogatory was sent or when the response was sent, because and that is very interesting to me, because another point, so remember how I said that a motion for summary judgment can be filed at any point during discovery, right? So you can get discovery responses and then jump right to filing a motion for summary judgment. If there has been some time in the process of discovery, so let's say this fifth interrogatory, this is interrogatory number 5. That means that um, if it's the way that I'm used to seeing interrogatories, it means that it's probably in the first set of interrogatories. You only get a certain amount to as a default. You can ask for more, usually, but anyhow, so this is probably one of the first bits of discovery that was sent to Amber Heard. And so what happens is, you send a discovery request to the other side, they give a response, and then both of you go on continuing your discovery process. You'll ask for information from one another. You might send subpoenas to other people to get information from them, so that you can maybe depose friends. You can, maybe get different document records from different third parties. Then you can so then, in the process of this whole thing, the response from the other person to this initial interrogatory that was sent at the beginning might then become not exactly accurate, because of the fact that there is more information that has not been sent to the person that requested it, right? So basically, there's updated information that should be sent to that person. So usually what happens is, when you have a motion for summary judgment in this kind of situation where there has been a lot of discovery that sort of happened since this particular request, where they detail the fifth interrogatory, there could be a situation where Amber Heard gave that response initially, saying Miss Heard will provide a substantive response, which basically means nothing, right? That's not like you're asking for specific evidence from them. Like, what is the evidence that you are basing your allegation on? And the response is, she'll provide a substantive response. That's like making an announcement that you're going to have an announcement later on. That means nothing. It means literally nothing. So this as a response is infuriating to me as a lawyer who has requested a lot of discovery. Um, Getting that kind of a response is annoying to me. But in this particular case, and part of me is like, I always, when I get a response like that, I always want to then send a meet and confer letter to the opposing party to be like, no, this is not a response. I need an actual response. Please send a real response. But in this particular case, the information that they are requesting is information that Amber actually really needs for her case to be able to prove her case. So getting kind of a non-answer basically suggests that she doesn't have any information. So in the process of getting, of the whole discovery, process, there may be a situation where the initial response is, she'll provide a substantive response at some point when, I don't know. So what you do is right before, or at least sometime before filing the motion for summary judgment, you can actually send a supplemental response saying, hey, send us any new information that you have that you didn't send us before when we initially requested this. And then you can basically be sure that they are not going to try to sort of hide the ball from you and surprise you in their response to your motion for summary judgment to say, oh no, we actually do have all of this evidence. And, now you just spent a bunch of time and energy and money because these things take a long time to put together. So now you've spent a bunch of time, money, and expense, whatever, for putting this motion together. And oh, by the way, we have all this evidence. But at the very least, then, this can be successful, even if Johnny Depp doesn't win on this motion for summary judgment. It could still be successful in that you get to see the evidence that they do have, because they have to provide it in order to, Amber Heard's team has to provide it in order to survive this motion. Because if they don't provide a response, if they don't provide evidence to back up their side on this, they are the ones with a burden here. So they can get their claims dismissed if they don't properly respond to this motion. So it kind of like, it kind of is a benefit to Johnny in both respects, regardless of whether he actually wins this particular motion. Forever Cuber, thank you so much for your super chat. Substantive response equals question. How do you keep a litigator in suspense? Answer: I'll tell you tomorrow. That's a good one. Okay, so the legal standard for a motion for summary judgment. The court can grant summary judgment as the material facts needed to adjudicate this motion are not subject to dispute. Summary judgment is justified against a party who fails to make showing sufficient to establish the existence of an element essential to that party's case and on which that party will bear the burden of proof at trial. Whoa, that's a lot of legalese, it sounds like, probably to a lot of people. Basically what this means is so a motion for summary judgment is asking for the court to make a judgment on the other party's claims, to say no jury should look at this. No jury should take any time to look at these claims, because we know at this stage, before we even get to trial, before we even get to picking any kind of a jury, we know that there is not enough evidence for the plaintiff to win no matter what, because they don't have it. There's no evidence for a jury to even weigh. And the evidence that we are talking about has to be evidence relating to a material issue in the case. So what you do is you look at the different elements, in this case, elements of defamation by or alleged by a public figure. And you go through, like I said before, all of those boxes that have to be checked. Each element. Is there evidence that fits in here? Is there evidence that fits in here? Is there evidence that fits in here? And if there's any box that is blank, then that claim has to be dismissed, because you know that there's no evidence that could possibly be placed in there for the jury to be to weigh, for them to decide on. So anyhow, so it's if there is any genuine issue as to a material fact. So, there could be some sort of light waffling on evidence, but basically, if, like I said, in cases where somebody who is making certain claims says or says that they have information, and then push comes to shove, they are requested to give that information, they don't provide it to the other side. This is a really good way to either force that information out, or to show the court they don't have this information, and their claim should be dismissed. Okay. So that's basically what that paragraph means. Argument. So now we're getting to the argument section. Okay. So we've got the three arguments. Number one is Ms. Heard has no evidence of direct liability. Ms. Heard alleges that Mr. Depp directly authorized and conspired with Mr. Waldman to make the counterclaim statements, but there is no evidence to that effect anywhere in the record. There is no evidence of any communication or coordination between Mr. Depp and Mr. Waldman regarding the counterclaim statements or anything else. Tellingly, in response to Mr. Depp's fifth interrogatory's request that Ms. Heard state the facts supporting her contention that Mr. Depp is responsible for Mr. Waldman's conduct, Ms. Heard has offered nothing but an unfulfilled promise to provide a substantive response. Ms. Heard carries the burden of proving her allegation that Mr. Depp intentionally directed Mr. Waldman's conduct. And that's kind of the kicker here, right? Because she's the one with the burden to prove, if she doesn't have evidence, she loses. That's just how the burden of proof works. If, on the other hand, Johnny Depp had the burden to prove any of these claims, it would be on him to provide it. It would be a serious bit of pressure on him to find that evidence, produce that evidence, square that all away. But in this case, with regard to the counterclaims, because Amber's the one with the burden of proof, if she doesn't have it, she loses. So, right. So in order to find Johnny Depp liable for any of these statements, remember, he didn't actually make any of these statements. All of them were made by Adam Waldman. So she has to not only show that Johnny Depp has some sort of a connection to him that could possibly make him somehow responsible for someone else's statement. Because remember, as we go through life, generally speaking, we are not responsible for what someone else does unless there is a very specific reason to put that responsibility on us. So usually we're talking about vicarious liability. Think of, for example, an employer that is responsible for one of its employees. Maybe a supervisor at work, for example. That's a good example of vicarious liability often. Or let's say a truck driver gets into an accident. That could be liability that the truck driver would have. That could be vicariously applied to his employer because he's in the process of doing his duties as an employee. Those duties benefit his employer. There's a whole sort of list of boxes to check in order to meet a standard for vicarious liability. You can also have liability if there's some sort of a conspiracy between them. So this whole first argument is saying there's no conspiracy. And in fact, and they don't actually need to show that there's no conspiracy. All they need to do is show that Amber Heard has no evidence that there is a conspiracy between them. So if she doesn't have any kind of evidence for that, then she can't claim conspiracy. She can. Now we'll get to number 2 where we are talking about vicarious liability. But so far, it's saying that there's nothing. She hasn't responded to the discovery in any substantive material way that would allow for any defendant to those claims to be able to kind of work with, So because she hasn't provided any kind of responses, which, by the way, she has a responsibility to do. Anytime any party gets discovery requests, they are supposed to provide good substantive responses to the best of their ability. You can't just shirk those. And my guess is the only reason why why Johnny Depp's attorneys kind of allowed that response to sit is because the evidence that would be forthcoming in that kind of a response would go to these counterclaims, which they don't have a burden to prove. The burden is on Amber Heard. So that is number 1. Argument number 2. Ms. Heard cannot prove actual malice by Mr. Waldman. To the extent Ms. Heard attempts to argue, contrary to her counterclaim, that she is merely seeking to hold Mr. Depp liable under a vicarious liability theory, Ms. Heard's arguments fare no better. To state the obvious, vicarious liability is liability for the tort of another person. So to hold Mr. Depp liable for Mr. Waldman's statements, Ms. Heard must establish that Mr. Waldman committed all elements of defamation. And this is true. This is very true. First, you have to, it's like when you have liability for that you are applying to one person because of something that somebody else said, you have to show, first off, that the thing that the other person said was actual defamation. And number 2, that you can extend that liability to that other person that you are actually suing. So this is pretty spot on. The elements of defamation are 1, publication of 2, an actionable statement with 3, the requisite intent. Um, I don't like that breakdown of elements because you still have to define actionable statement. What does an actionable statement mean? Basically, this is just how Virginia breaks it down, but it basically means the same thing across most states, that somebody lied about the plaintiff to another person or group of people, and the result of that lie is that there was some serious reputational harm, um, and that there was a certain level of intent. Okay. Anyway, back to the actual motion for summary judgment. A public figure must prove by clear and convincing evidence that a defamatory statement was made with actual malice, i.e., knowledge that it was false or with reckless disregard or of whether it was false or not. Reckless disregard, quote, is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. There must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication, unquote. And this is, of course, citing to U.S. Supreme Court case law. The Virginia Supreme Court has confirmed that summary judgment is appropriately granted against a plaintiff that fails to present evidence from which a jury could find actual malice by clear and convincing evidence. Here, Ms. Heard is a public figure and, as such, must establish that Mr. Waldman uttered a defamatory statement about her with actual malice. There is no evidence in the record that Mr. Waldman knew the counterclaim statements were false, nor is there any evidence in the record that Mr. Waldman subjectively entertained serious doubts about the falsity of the counterclaim statements. Ms. Heard's factually empty response to Mr. Depp's fifth interrogatories is damning. She had an opportunity to explain how Mr. Depp can be held legally responsible, which requires as a threshold matter establishing that Mr. Waldman committed the tort, including acting with actual malice. She cannot meet her burden. Yeah, no, I mean this. If that's the case, like I said, I wish that the separate statement were, you know, although I guess it really wouldn't matter here if this is the only possible evidence is, they requested her response to the fifth interrogatory, and she just didn't really respond with any kind of real substance. I think, yeah, I mean, if there's no evidence, there's no evidence despite them requesting it. It'll be interesting to see what their response is to this. Because I don't know if there has been any kind of request to depose Adam Waldman, but that's so tricky anyway. Like trying to depose the opposing party's attorney or former attorney, because I know that right now there's a deposition request by Johnny Depp's legal team to depose Amber Heard's former attorney. And I know that there's been a motion for a protective order that was filed for that. Oh, Adam Waldman was deposed? I'm seeing that in the chat. On February 15th, he was deposed. Interesting. So that's even more interesting. Although, okay, so in Virginia's funny because apparently I was reading. So I'm not licensed in Virginia. I'm licensed in California and DC. But I was, to prep for this, I was reading that in Virginia, a motion for summary judgment cannot even use a deposition. It can't use deposition testimony for either to support or to fight against a motion for summary judgment, which is just weird to me because I'm so used to California where you can use literally any and all of the evidence that has been sent around between the parties. So it's interesting. It's interesting to me that that they can't use it here unless they have somehow agreed to it, which my guess is that they haven't, unless somebody knows otherwise. But so even though he apparently has been deposed, number one, I'm very curious as to how that went, because they typically cannot get into um the there's a lot that they usually can't get into because of the fact that the um the relationship between the two of them, the communications between them are usually privileged because of the fact that we're talking about an attorney and a client. So anyhow, weird. I'm very curious to know how that actually went down. But I would also like to know if there really is any other evidence, because if this is it, the response to the fifth interrogatory, I don't know how Amber Heard's attorneys are going to respond to this motion. Because it's true. In order for her to show that Johnny Depp was somehow vicariously liable, she would need to show that Adam Waldman acted with actual malice, which is a very high burden. Anyhow, okay. Argument number 3. In context, the counterclaim statements are protected opinion. Finally, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. Indeed, a statement cannot be defamatory if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. Pure expressions of opinion cannot form the basis of an action for defamation. And then it cites to some Virginia case law, noting that where all sides of the issue, as well as the rationale for the speaker's view, were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, and finding an accusation of deceit to be opinion. So basically, where you have the reasons for, this person, why they're saying what they're saying, you're showing that this person is somebody's lawyer. Of course, like that's enough information right there to be able to take anything that they say with a grain of salt, because of course they're going to be supporting their client because they kind of have to as their lawyer. As is explicitly reflected in statements F, G, and H, the counterclaim statements were each made in the context of highly public and contentious litigation with conflicting testimony from both sides. Each article lays out two diametrically opposing characterizations of the facts by opposing attorneys. Each article presents Mr. Waldman's assessment of particular items of evidence or developments and the opposing side's very different assessment. Each article is explicit that the facts are very much in dispute. Indeed, the main thrust of each article is to describe the clash of completely different views between the Depp and Heard camps. Oh, hey, Kurt. How's it going? Uncivil Law. Good to see you in the chat. In context, any reporter or reasonable reader would understand and expect a lawyer associated with Mr. Depp to challenge Ms. Heard's version of the inherently murky events of the parties' marriage, just as Ms. Heard's lawyers challenged Mr. Depp. I mean, yeah, that's my reading of those statements. That context necessarily negates any suggestion that the statements are properly understood as subjective statements of fact that could be deemed defamatory. And then it cites to the case Chaves, another Virginia case. The most unsophisticated recipient of such a claim made by one competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias. That seems to be pretty applicable in this case, and then they cite to Partington v. Bugliosi. And now this one is a Ninth Circuit opinion, so it's not Virginia, but it's supportive anyway, and the court can use it if they want. It says if a statement is made in a forum in which a reader would be likely to recognize that the critiques represent the highly subjective opinions of the author and relates to inherently ambiguous subject matter about which reasonable minds could draw different conclusions. Hey, it's like they've been watching Hoaglaw's channel. Reasonable minds can differ. then the general context in which the statements were made negates the impression that they imply a false assertion of fact. And it seems like, I mean, yeah, like if the quotations were in the they're in this article immediately following or immediately before statements by Amber Heard's attorney or, counsel for the son. It seems like, I don't know, this is it fits in this case law precisely. Mr. Waldman's opinions are not presented as a definitive version of events or as statements of a percipient witness, but as mere advocacy, one side of a fiercely contested story as characterized by a lawyer, where it is clear from context and the content of the statements that the facts are contested. I kind of agree. And then it cites to Potomac Valve and Fitting Inc., the Crawford Fitting Company. This is Fourth Circuit, so it's federal court, but that is where Virginia is in the Fourth Circuit. It says that the case said that the summary judgment is appropriate where the statement in question readily appears to be nothing more than the author's personal inference, and where a reasonable reader would recognize the author as biased and would not expect a dispassionate and impartial assessment. Mr. Waldman is never described as a fact witness with personal knowledge, but merely a lawyer, a partisan hired gun, expressing his opinion and evaluation about a he said, she said dispute. More case law from the Fourth Circuit saying no liability where there was no claim to firsthand knowledge of facts, and the context and tenor of the article thus suggests that it reflects the writer's subjective and speculative supposition. Yeah, I mean, this is about correct. I'm going to skip just a little bit ahead. Ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view and interpretation, a theory, a conjecture, or surmise about events he never claims to have witnessed. No reasonable reader would believe otherwise, especially as Mr. Waldman's statements are directly contradicted by Ms. Heard's lawyers in the same circles. The same articles. Moreover, the recipients of Mr. Waldman's statements, whether reporters or readers, were necessarily informed of the existence of factual disputes, the reporters having written articles about describing the disputes, and the readers having read them, which negates defamation. The statements are no more than vivid expressions of opinion from which no liability for defamation can arise. For the foregoing reasons, the court should grant the motion. And then that's the end of it. So, okay. So, looking at something that was interesting when I was kind of I was trying to find some of the arguments whether any of these arguments were made before. Like I said earlier, I was looking at the possibility of litigation privilege, which is basically where an attorney can make statements that otherwise could be totally defamatory if they are in direct connection with litigation that is ongoing, or that even is not necessarily ongoing, but is they're in preparation for it, and they have pretty good preparation for it. There's a reasonable certainty that it's going to happen. And it was interesting to me that was not an argument in this motion. That all of these statements, to me, when I first read them, was all of these are statements to the press having to do with this lawsuit that was happening in the UK. And the reason why they're having to do with the lawsuit is because that lawsuit was about an article published in The Sun that referred to Johnny Depp as a quote unquote wife beater. That was a result of the it was a result of her claims, of Amber Heard's claims. So I want to do another video that is just kind of talking about some of the similarities and differences between that lawsuit and the one directly against Amber Heard. But there are a number of reasons why the lawsuit against The Sun can come to a completely different conclusion than the one against Amber Heard herself. But it's interesting to me that was, like I said, that was not an argument in here that the statements that were made should be covered by the litigation privilege, I would think. Now I'm going to continue. I'm going to continue doing some research into the litigation privilege in Virginia specifically, because it could very well be that maybe there's just certain limitations on it. Number one, the statements were made at the time not in relation to this specific lawsuit, the one that is ongoing right now, but it was related to the prior lawsuit. So the court, I did read the court's opinion. I saw somebody earlier, I think, in the chat mentioned something about how the court had kind of talked about this. And it's true that the court did refer to some of those statements in kind of that way, but it wasn't exactly clear to me that what they were talking about specifically was litigation privilege. Let me see here. Let me take a look at my notes for that now that I have taken down the PDF. Okay. Oh, did I not write it down in here? Dang it. Okay. Sorry, guys. Give me 1 second. Okay. So yeah, there's a portion here in the give me 1 second here. Okay, there's a portion here in the actually, you know what? I am going to share this screen. Okay, this is from the opinion by the court, where they do refer to Mr. Depp's statements not being fair and accurate accounts. And I think that they don't exactly use the term litigation privilege, but I think that this is what they are talking about. And to respond to something in the chat, so talking to the press wouldn't necessarily be covered. It would actually. There is case law showing that there are other cases where statements made to the press were covered. It's just, it depends on. It seems like this court. I'm not exactly sure if I agree with the court on this one, but usually, so litigation privilege is like, if the statement refers pretty directly to litigation that is actually ongoing, and if you're making a statement about the opposing party in the case, like that falls pretty squarely in it. But I think that maybe one of the things that kind of gets hung up in this particular case is those statements during the Sun litigation. Amber Heard was not a party to the litigation at that time, although she was very much the subject of the litigation. So I haven't been able to find any case law talking about that kind of a situation where you have someone that is not a party but is a subject of the litigation, and where that falls. To me, just kind of taking a step back and using common sense, it seems like the reasons for the litigation privilege are basically so that any attorney that has been hired to zealously advocate for their client is allowed to do that, right? Like, you need to give them some amount of space, some amount of breathing room to be able to make the claims on behalf of your client, regardless of whether or not you believe that. Because let's be real, when we are talking about lawyers and believing their clients, like, try to find any lawyer who has been practicing for really any amount of time. Let's say even just a baby lawyer who's been practicing for a year, who's actually been in litigation, right? Active litigation. Ask them if they truly believed everything that their client actually told them and that they had to argue in court. Let's say if they really believed in every single argument that they had to make in every motion and every court appearance and every statement that they made on behalf of their client. No way. If lawyers only represented clients that they actually fully believed 100% all the time, and they didn't ever represent anyone, and they didn't represent anyone else that like they had the remotest, feeling that maybe they might not be totally honest, like you wouldn't be getting that much business. Right? So every lawyer needs a certain amount of space to be able to make the claims that they can make the arguments that they can make so that they can zealously advocate for their client regardless of whether or not, the arguments fall one way or another on their BS meter, right? Because everybody has one. Um, so anyway, so that's the reason for the litigation privilege is that like I said, like the lawyer needs to have some breathing room to not worry about getting liability just for zealously advocating. And of course there are limits to zealous advocacy, like you can't go too far that you're, you know, uh playing dirty, so to speak. Anyhow. So because of that, because of the policy reasons for why the litigation privilege kind of even exists in the first place, it would seem strange to me if statements made about a person who isn't a party but is the central subject of the litigation, if statements to the press about that litigation and about that person within that litigation, if those were somehow not covered by the litigation privilege, it would be very surprising to me. But it is possible because like I said, I haven't found case law specifically on that like little like narrow issue. um So anyhow, okay, but looking back at the here. Oh, and here's a question in the chat. How is there a limit of zealous advocacy? You're supposed to fight for your client's livelihood, right? So, I mean, yes, you are supposed to fight for your client so that I mean, you're supposed to fight as, like I said, as a zealous advocate, but there are limits in the way that you are not supposed to go so far that you start to play dirty, like as in you start to be dishonest, as in you start to play games that disadvantage the opposing side in an unfair kind of way. So, for example, withholding evidence that you are supposed to give over because they've requested it, like that would be an example that technically is very zealous advocacy, but can run into other professional responsibility rules and other discovery rules and whatnot. So that's what I mean by limits on that. Um, okay, so Mr. Depp's statements are not fair and accurate. So this is from the court's opinion um on the demur to Amber Heard's counterclaims. This is the opinion that basically cut down her allegations to just those three statements, F, G, and H, right? Okay, it says Mr. Depp argues that his statements are protected as fair and accurate accounts of his lawsuit. Because a party has a right to institute and prosecute an action without fear of being mulched in damages for reflections cast upon the defendants, no action for defamation can lie from a publication that constitutes a fair and accurate account of the issues in suit. So that does sound a lot like the litigation privilege, even though they don't actually use the term for it. And then they cite to Bull v. Logetronics Inc., which is a Virginia case. In Bull, the court considered a press release that stated 1, the plaintiff sued defendants for conspiracy to defraud. 2, plaintiff sued for royalty payments and damages in an amount over $1 million. $1 million. And 3, plaintiff was seeking punitive damages, alleging a conspiracy to circumvent the provisions of a contract relating to manufacture and sale of film processors under U.S. patents. The court held that those statements were a fair and accurate summary of the allegations. I mean, it seems like what they're saying here is that what I don't like about using this case as reasoning is that this shows this is using case law to show where it has worked, right? Where it is privileged. But then they're using that to show in this case why it isn't privileged. And it doesn't exactly give a good reason for it, right? Because it's like it's kind of but why? But why? So okay, so this one doesn't um like Zens. Yes, yes, I did do the evil the Dr. Evil Pinky thing. um okay, anyhow, but so this doesn't exactly give reasoning for why. And now I'll read the next paragraph. Here, Mr. Depp's statements are notably different than those in Bull. Although much of what Mr. Depp states is also contained in his complaint, the statements do not appear to have been made in the context of attempting to recount litigation. Instead, Mr. Depp makes factual assertions that do not fairly and accurately summarize the litigation that has taken place. Accordingly, his statements are not protected. So the statements here, I mean, and now I'm without going too deep into this opinion, but it's saying Mr. Depp's statements. It's not saying Mr. Waldman's statements, because this opinion here is it distinguishes between Johnny Depp and Adam Waldman and the statements that they made, because this one is looking at a ton of different statements that were all of the ones that were alleged in the counterclaims. So it's interesting to me because it seems like this analysis is saying that Johnny Depp's statements, maybe the GQ article or the other statements that are attributed to him in the counterclaims, that those are not exactly fair and accurate summaries of the litigation that has taken place. It doesn't really go into much more detail. So I'll read on. Although Mr. Depp's statements may have been made in self-defense, Ms. Heard has alleged sufficient malice for her defamation allegations to survive demur. Under Haycox v. Dunn, so long as Mr. Depp's statements were repelling the charge and not with malice, his statements would have been made in self-defense and therefore would be privileged. There, the court recognized that generally the rule is that the court's duty to determine as a matter of law whether the occasion is privileged, while the question of whether or not the defendant was actuated by malice and has abused the occasion and exceeded his privilege are questions of fact for the jury. So anytime that the court is pointing to case law that says that this is a question of fact for the jury, you know that it is not going to be that this is not going to be a winner on a motion to dismiss, because like I said at the very beginning, a motion to dismiss is going to assume that the facts that were alleged are true. But when it comes to a motion for summary judgment, the court does look at the facts. The court does look at the evidence that both sides have. Now, when it comes to weighing that evidence, if it's something that has any shade of gray to be weighed, any amount, then that's something that is going to be sent off to a jury. But if it's basically black and white evidence as to material issues of fact, then it's something that's going to be a winner for the motion for summary judgment. Anyhow, okay. So yeah, I'm still not really convinced that this is a good opinion on that specific issue about the litigation privilege. I'm still not sure why they didn't reassert it in the motion for summary judgment. Because all of those statements were made by a lawyer who was acting in his scope of responsibility, scope of duties as a lawyer in the context of litigation. So anyhow, I'm probably going to think on this one a little bit further, and maybe I'll do a separate video kind of talking about that, because I've gone on for a little bit. But I think there was something else that I wanted to talk about in this situation. Dang it, there was something else. Oh, yeah. Okay. So the third argument in the motion for summary judgment, their third argument is that uh, Waldman's statements are non-actionable opinions. They tried using this argument in their demur, right? In this right here that I'm showing you guys. And that didn't end up winning. I mean, obviously, because if it had, then the statements F through G wouldn't be at issue, right? The whole counterclaim would have been the whole counterclaim would have been dismissed entirely, right? We wouldn't even have statements F, G, and H or whatever. But the court ended up saying that the argument that the statements are non-actionable opinions, right? They're basically saying these are not statements of fact. You cannot apply defamation liability to someone for stating an opinion, right? Now, sometimes context matters, right? Because somebody can say something, and then later say, no, that's just my opinion. But if they say it in such a way that it sounds very definitive and it sounds very factual, and the context of what they're saying would lead a reasonable person to believe that what they are saying is more factual than opinion, then that's something that is a statement that is actionable. Now, when we are talking about opinion, though, anybody can have an opinion. If you have a belly button, you can have an opinion, right? So what they're saying is all of the statements by Mr. Waldman were just his opinion that her claims are a hoax, his opinion that her claims, are not going to are going to be shown to be false, right? Because there's police reports, there's all kinds of stuff. And the conclusion by the court, and let me see if I can find this here. Because I have it written down in my notes, but dang it. Hang on a second. Let me take another part of this quote here because I want you guys to see it while I read it. Why is this being so lame? Okay. So the part about protected opinion statements that the court, the part about protected opinion statements that the court went over in the demur, or in their opinion about the demur is right here. So it says here, protected opinion statements. A statement is generally not defamatory when it is dependent on the speaker's viewpoint, where the context of the statements and the positions of the people reading the statements would allow them to reasonably conclude that the statement was purely her own subjective analysis. The statement is not actionable. However, even opinion statements are actionable if they imply an assertion of objective fact. Although Mr. Depp's statements and those of his attorney can be understood as their opinion of what occurred, these statements nevertheless imply that Mr. Depp did not abuse Ms. Heard. These statements must survive demur because whether Mr. Depp abused Ms. Heard is a fact that is capable of being proven true or false. So, and that may actually be, I mean, now that I've been thinking about this out loud, about the part about the litigation privilege, this may actually be why they decided not to even include the litigation privilege argument in the motion for summary judgment. I personally wouldn't agree with that, but so this is just kind of a bit of an easier argument, I think, given what the court said about this right here. What they're saying is not that the opinion statements are going to be around in this litigation forever. Really, just that they just meet the threshold for a demur, which, as I said, you have a demur and then you have a motion for summary judgment. These are different legal standards. The motion for summary judgment comes a lot later than the motion to dismiss or the demur. And the burden as you get closer to trial to um the burden for the plaintiff gets a little bit higher, for that the hurdle that they have to jump over to survive and continue on with the litigation gets a little bit higher as they go closer to trial. So the lowest possible standard for a plaintiff to meet is the demurrer standard, where they said that these statements must survive demurrer because whether Mr. Depp abused Ms. Heard is a fact that is capable of being proven true or false. So it's capable of being proven true or false. Basically, the court said this is a fact that has been alleged. It could be true, it could be false, but we're not at the stage of the litigation where we are able to make that determination, because that just happens later on in the litigation. You need to go through discovery to figure that out. So now we are at the point of the litigation where discovery has happened, and they say, and Johnny Depp's attorneys are saying, well, okay, despite after hearing this from the court, that the statements must survive demurrer because whether Mr. Depp abused Ms. Heard is a fact that is capable of being proven true or false. That the statements of opinion, like if there is evidence or is no evidence, that's something that is, I guess, easier for the defendant to make go away because of the fact that there is allegedly, apparently, according to the motion for summary judgment, no evidence to support Amber Heard's claim on this. I don't know. Anyway, we'll see. We'll see how it goes. But the fact that it survived a motion to dismiss or a demur does not mean that these statements will survive the motion for summary judgment. I am very, very, very interested to see what Amber Heard's attorney's response will be to this motion for summary judgment, because I think that the arguments are pretty good, but this is one side. So I want to see, give them your best shot, right? And let's take a look and see if these last three statements can ultimately be dismissed or not. If they can, then that basically means that Amber Heard's counterclaims entirely go away. If she has no statements that are allegedly defamatory, then you have you definitely can't meet any of the elements of defamation. So in which case we would be back to kind of square one, where all we're talking about is the complaint that was filed by Johnny Depp. So anyhow, what are your guys' thoughts? Let me know in the chat. Let me know in the comments down below if you are watching this on the replay, or if you're listening through the podcast. This is such an interesting case, and I like I said before, I feel like Alice in Wonderland. Like the deeper I go, the crazier things get. I'm just going down the rabbit hole, and I'm super interested. And like I said, also at the beginning, if cameras really will be allowed in the courtroom, I am going to be live streaming that trial on this channel, like the entire thing, morning till night, however long trial goes on for. I want to, because it is so fascinating, so interesting. And even if they don't allow cameras in the courtroom, I legitimately will fly to the DC area to actually go to the courthouse and watch in person and see if I can live tweet if they allow phones in the courtroom. And if not, then do regular updates every day, kind of like what Good Logic did with the Ghislaine Maxwell trial, because that I think is super important, because of the fact that there's really not much, if any, media reporting on this case, and the reporting that has been there, let's face it, has been very favorable to Miss Heard. for, one reason or another. I'm sure we all have, have our theories as to why. But um, yeah. Oh, Laura B. Hey, by the way, thanks for watching. The real Laura B said the judge already ruled on one pool camera, no live tweeting allowed. Okay. So yeah, if there is a way that that pool camera is able to get out, I mean, because sometimes courts will be funny. I know a bunch of us in LawTube have been kind of talking about, um, we've been talking about the Jussie Smollett sentencing hearing that's supposed to be tomorrow. And there's actually like live streaming that that the court is doing um for the sentencing hearing, and yet they also have rules saying that you cannot publish. So a bunch of us want to be on. I think Nate the lawyer is the one that actually wants to be live streaming that one and commenting on it. And so a bunch of us want to join him on his channel for that. So, but courts can be funny with their rules, even if there is technically some kind of broadcasting of this stuff. So I want to make sure that I'm doing everything above board, and if worse comes to worse, I will freaking be there in the courtroom as best that I can. I want to get my butt in there. But anyhow, that is that. Let me know what you guys think about this. And if you guys have any other questions, any other stuff that you want me to cover, I'm already thinking of other topics that I want to cover just to kind of get up to speed on this case, because like I said, it's super fascinating. And it's been a very interesting case to really dig into and sink my teeth into. So, and also, like, I will say this, my my impression of Johnny Depp over the years, I've always loved his movies. I've loved Pirates of the Caribbean. Um, I've always loved Pirates of the Caribbean. I've always loved I feel like I watch more Johnny Depp movies than any other, movies or any other like actors movies in October, right? Because it's like he's got a lot of stuff with Tim Burton and whatnot. So I've always been a fan of his work. And I have also, like, growing up in Southern California, I had, one of my best friends worked at Disneyland. And so she had a lot of stories about that she knew of him being at Disneyland, and, just kind of like through that sort of Disney connection, like just stories that she knew about him. So all of it, obviously, that I know is hearsay, but I have heard many, many accounts of his generosity, both with his time and with his money. Like the guy would get dressed up as Captain Jack Sparrow, either while they were filming and go off set, or just like he had the costume and just would go on his own and like go to a kid's hospital to like cheer kids up. Like, this is the kind of stuff that I remember hearing about. So it made me really sad when I heard about this kind of stuff coming out, starting around 2016. But I wasn't live streaming legal stuff on YouTube until like a couple years ago now. And so anyway, this hadn't really come across my radar to really dig in really deep. So anyhow, it made me really, really sad to hear that. And if in fact, like, the situation is not the way that the media has been portraying it, I mean, after the Kyle Rittenhouse trial situation played out very differently than what the media was saying, it doesn't exactly surprise me that the media is like that. But B, that's just tragic that the guy has been living through this for how many years, and especially over a marriage that only lasted like 15 months. It sucks. It sucks. It makes me really sad. So anyway, there's a lot of reasons why I am very, very drawn to this case. But anyhow, one last super chat. Britt Cormier, thank you so much. He says, media being silent about the crazy actions of a famous woman? Tell me it is not true. It would shatter my reality. I mean, it's media sometimes has been found to lie about men and women. Let's be real about that. I'm an equal opportunity person. So anyhow, with that, let me know if you guys have any other stuff that you want me to talk about. Like I said, I'm going to talk about some I've got some ideas already, but and also collabs with other people. I saw the real Laura B's in the chat. Thank you so much. I saw that umbrella guy was in the chat. That was awesome. Thanks so much for jumping in, and I would love to collaborate with you guys too, and really kind of get into the nuts and bolts and dig into this case super well. Anyhow, okay, that's all I've got. I'm rambling now. I'll talk to you guys in the next video.